A director attends every board meeting, participates in strategic decisions, approves financial statements, signs corporate documents, and suddenly one day the company discovers that the director never received formal appointment approval in the general meeting. Overnight, questions arise regarding validity of participation, governance legitimacy, board authority, and compliance failures. But under Section 176 of the Companies Act 2013, the law creates a powerful governance safeguard. Acts done by a person as director remain valid even if appointment defects are later discovered. This small looking provision protects companies from operational collapse, but at the same time raises dangerous governance questions involving defective appointments, procedural manipulation, and boardroom legitimacy. Every director, company secretary, auditor, advocate, investor, and governance professional must deeply understand Section 176 because this provision sits at the intersection of governance continuity, procedural compliance, and corporate stability. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Today, we are discussing one of the most overlooked but extremely practical governance provisions under the Companies Act 2013, Section 176, dealing with defects in appointment of directors. Not to invalidate actions taken. At first glance, this provision appears simple. Many students read it quickly and assume it is merely technical. But in actual corporate governance, Section 176 becomes critically important during litigation, secretarial audits, investigations, due diligence, M&A transactions, SEBI scrutiny, shareholder disputes, boardroom conflicts. This provision protects corporate functioning from total instability merely because defects are later discovered in director appointments. To understand Section 176 properly, we must first understand a fundamental governance reality. Modern companies function continuously. Boards approve contracts, borrowings, investments, financial statements, strategic transactions, regulatory filings, corporate restructuring, fundraising activities. Now imagine if every action taken by a director automatically became invalid merely because some technical appointment defect was later discovered. Corporate governance would become chaotic. Commercial certainty would collapse. Third parties would hesitate to transact with companies. This is exactly why Section 176 exists. The legislative philosophy behind this provision is corporate continuity and protection of bona fide actions. The law recognizes that procedural defects may sometimes occur despite genuine governance functioning. Companies should not automatically collapse into uncertainty due to every technical irregularity. However, the provision does not protect fraud or deliberate governance abuse. This distinction is extremely important. Now let us understand the statutory framework in simplified professional language. Section 176 broadly provides that acts done by a person as director shall remain valid notwithstanding that it may afterwards be discovered that appointment was invalid due to defect or disqualification or had terminated by virtue of provisions of the Act. This creates a legal protection mechanism preserving governance continuity. Now let us carefully understand the phrase afterwards discovered. This means the defect was not initially known during functioning. The provision protects actions taken before discovery of the defect. This becomes extremely important during practical litigation. Suppose everyone genuinely believed the appointment was valid and governance decisions were taken accordingly. Section 176 may protect those decisions. Now let us discuss the phrase acts done by a person as director. This phrase is broad. It may include participation in board meetings, resolution approvals, committee decisions, contract authorizations, corporate governance actions, compliance approvals. However, practical application always depends upon facts and judicial interpretation. Now let us discuss legislative intent more deeply. Why does law provide such protection? Because corporate governance requires operational certainty. Third parties such as banks, investors, vendors, regulators, employees, shareholders rely upon apparent authority of directors. If later technical defects automatically destroyed all decisions, commercial confidence would disappear. Section 176 therefore protects both companies and external stakeholders. Now let us discuss historical governance background. Traditional company law recognized the de facto director doctrine. This doctrine accepted that individuals acting under appearance of authority could bind the company in many circumstances despite appointment irregularities. Courts historically balanced procedural compliance, commercial practicality, stakeholder protection. Section 176 reflects this mature governance philosophy. Now let us discuss practical examples. Suppose a director was appointed through board resolution, but the company inadvertently failed to obtain shareholder approval within required timelines where necessary. Meanwhile, the director participated in multiple governance decisions. Years later, during due diligence, the defect emerges. Without Section 176, enormous uncertainty could arise regarding validity of historical actions. This provision, therefore, stabilizes governance continuity. Now consider another situation. A director incurred disqualification under Section 164 due to compliance default, but the company discovered it only later. During the intervening period, the director attended meetings and approved decisions. Again, Section 176 may become highly relevant. Now let us discuss an extremely important practical distinction. Section 176 protects validity of actions in many circumstances, but it does not excuse non-compliance itself. The underlying appointment defect may still attract penalties, governance criticism, secretarial audit observations, regulatory scrutiny. Students often misunderstand this point. Protection of actions does not automatically eliminate all compliance consequences. Now let us discuss practical governance risks. Promoters sometimes misuse procedural irregularities strategically. For example, appointment approvals delayed intentionally, independent director eligibility ignored, DIN compliance overlooked, shareholder approvals manipulated. Later, companies attempt to rely on Section 176 broadly. Courts and regulators carefully examine whether defects were technical, accidental, good faith errors, or deliberate governance manipulation. This distinction becomes crucial. Now let us discuss interaction with Section 152 relating to appointment of directors. Proper appointment procedures remain fundamentally important. Section 176 is protective, not substitutive. Companies cannot ignore appointment formalities, assuming Section 176 will rescue them later. That approach is extremely dangerous. Now let us discuss interaction with Section 164 and Section 167. Disqualification and vacation of office provisions directly affect governance validity questions. Suppose a director automatically vacates office due to disqualification but continues participating unknowingly. Section 176 may become relevant while evaluating historical decisions before discovery. This interconnected governance analysis is very important. Now let us discuss practical board meeting implications. Whenever companies discover appointment defects, immediate governance response becomes critical. The board should review legal implications, seek professional advice, regularize defects where possible, evaluate historical approvals, assess disclosure obligations, document corrective actions. Weak response management increases litigation exposure. Now let us discuss practical role of company secretary. The company secretary acts as governance gatekeeper. Responsibilities include monitoring appointment timelines, verifying eligibility, tracking shareholder approvals, maintaining statutory registers, ensuring DIR filings, monitoring disqualification risks. Strong secretarial systems reduce dependence on curative provisions like Section 176. Now let us discuss ROC filing implications. Defective appointments frequently involve issues relating to DIR 12, consent filings, declarations, DIN compliance, shareholder approval filings. Inconsistent MCA records create governance red flags. Section 176 may protect certain actions, but ROC non-compliance issues may still persist. Now let us discuss practical due diligence perspectives. During mergers, acquisitions, and IPO preparation, legal teams carefully review director appointment history, shareholder approvals, DIR filings, eligibility documentation, board composition continuity. Defective appointments create transaction concerns. Section 176 often becomes central while evaluating whether historical decisions remain commercially reliable. This makes the provision extremely important in corporate transactions. Now let us discuss practical litigation scenarios. Suppose shareholders challenge borrowings approved by a director later discovered to be disqualified. Courts may examine whether defect was known, whether parties acted in good faith, whether third parties relied on apparent authority, whether fraud existed, whether governance manipulation occurred. Section 176 becomes critical to legal analysis. Now let us discuss practical family business governance. Family-controlled companies often operate informally. Appointments are sometimes delayed, improperly documented, or casually regularized later. During succession disputes or shareholder conflicts, parties suddenly challenge years of board functioning. Section 176 frequently becomes important in such disputes. This is extremely common in Indian corporate litigation. Now let us discuss practical startup governance. Startups frequently experience rapid appointments, investor nominee changes, board restructuring, cross-border governance issues. Procedural lapses occasionally occur. During future funding rounds or acquisitions, investors analyze whether governance continuity remains protected despite historical irregularities. Now let us discuss judicial principles. Courts generally attempt balancing commercial certainty, good faith governance, stakeholder protection, procedural compliance. Technical defects may receive contextual treatment where genuine governance functioning existed honestly. However, deliberate governance abuse receives little judicial sympathy. Now let us discuss practical secretarial audit implications. Secretarial auditors frequently review director eligibility, appointment validity, shareholder approvals, DIR filings, board composition compliance. Defects may lead to qualifications, observations, governance warnings. Even where Section 176 protects historical actions, governance credibility may still suffer. Now let us discuss interaction with SEBI governance frameworks. Listed entities face heightened scrutiny regarding board composition, independent director validity, committee constitution, governance disclosures. Improper appointments, especially involving independent directors, may trigger SEBI scrutiny, stock exchange concerns, proxy advisor criticism, institutional investor dissatisfaction. Section 176 may not eliminate reputational consequences. Now let us discuss practical governance illustrations. Imagine a listed company where an independent director's appointment lacked proper shareholder approval due to procedural oversight. Meanwhile, the director participated in audit committee approvals and financial statement reviews for months. Later, during regulatory inspection, the defect emerges. Without Section 176, serious uncertainty would arise regarding validity of financial approvals and governance actions. This demonstrates the provision's stabilizing role. Now imagine another situation. Promoters knowingly continue using disqualified directors to manipulate approvals benefiting related entities. Later, disputes emerge. Courts may examine governance intent critically. Section 176 cannot become shield for dishonest conduct. This distinction is absolutely essential. Now let us discuss practical drafting precautions. Companies should maintain appointment letters, consent forms, eligibility declarations, DIR filings, shareholder approval records, minutes, register entries. Strong documentation prevents governance uncertainty. One common mistake involves assuming oral consent or informal understanding is sufficient. Professional governance requires documentary discipline. Now let us discuss penalties and consequences. While Section 176 may preserve validity of actions, companies and officers may still face compliance penalties, regulatory observations, secretarial audit remarks, governance criticism, investor distrust. Therefore, preventive compliance remains essential. Now let us discuss hidden examination traps. Students often incorrectly assume defective appointment automatically invalidates all decisions. Incorrect. Another common mistake involves believing Section 176 cures every governance problem completely. Again, incorrect. The provision protects certain actions but does not erase all legal consequences. Another hidden concept involves distinction between technical defect, substantive illegality, fraudulent governance conduct. Understanding these conceptual differences is extremely important. Now let us discuss investor protection perspectives. Investors expect governance stability. They do not want companies collapsing into uncertainty because of minor technical appointment defects. At the same time, investors also expect strong compliance culture. Section 176 balances these competing governance expectations. Now let us discuss practical compliance strategies. Good companies implement director compliance trackers, appointment calendars, digital governance systems, eligibility verification processes, periodic secretarial reviews, board composition monitoring. Strong governance systems reduce litigation exposure significantly. Now let us discuss broader governance philosophy. Corporate law recognizes practical realities. Absolute perfection in governance procedures may not always occur, but the law also expects honesty, diligence, and procedural discipline. Section 176 reflects this mature balance between commercial continuity, procedural compliance, stakeholder protection, governance integrity. Ultimately, this provision teaches one powerful governance lesson. Corporate law protects genuine business continuity and bona fide governance actions, but it does not encourage careless compliance or deliberate manipulation. A company cannot casually ignore appointment procedures expecting automatic protection later. Section 176 acts as governance stabilizer, not governance shortcut. For company secretaries, Section 176 highlights the importance of preventive governance discipline. For directors, it reinforces the need to verify eligibility and appointment validity. For investors, it protects commercial certainty. For regulators, it balances practicality with accountability. For advocates, auditors, and governance professionals, it becomes a crucial litigation, due diligence, and advisory provision. And for every learner of corporate and securities law, Section 176 remains one of the clearest examples showing how modern company law balances technical procedural compliance with practical business continuity in real-world governance environments involving thousands of stakeholders and crores of rupees in corporate decisions. If you like this video, kindly like, subscribe, and hit the bell icon for latest notifications from corporate and securities law compass. Like, share, comment, subscribe. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.